happens when power becomes so confident in its own story that it forgets the system it depends on to survive? When certainty hardens into habit and habit into authority that no longer questions itself. This is not a fight between people or parties, but a quiet examination of how institutions bend, how rules are tested, and what follows when belief in control begins to outpace the limits of law itself. The Senate hearing room did not announce its importance with noise. It never does. Power, when it believes itself embedded in the architecture, prefers quiet. The lights above the long dais were steady and unforgiving, calibrated for record, not drama. Nameplates sat evenly spaced, water glasses untouched. At the center of it all, Senator John Kennedy of Louisiana rested his hands on the desk, fingers lightly interlaced, eyes already fixed on the witnesses before him. Across the table sat a panel of legal scholars and practitioners, among them Professor Kate Shaw, composed, attentive, posture upright, in a way that suggested preparation rather than comfort. These were people accustomed to speaking in measured tones, to choosing words that survive transcripts and clips alike. The room smelled faintly of paper and polish. The audience was sparse. The stakes were not. Kennedy did not begin with an accusation. He rarely did. He began with a question so basic, it sounded almost naive to anyone unfamiliar with how systems fracture. Would any of you advise a client to defy a federal court order? There was a pause. Not a dramatic one, a professional one. Several witnesses exchanged brief glances with their notes. This was not a trick question. In American law, there are very few propositions that remain close to absolute, but this is one of them. Court orders are followed. Not because judges are immune from error, but because the alternative dissolves the architecture itself. One by one, the answers came. No, absolutely not. Under no circumstances. The rule of law depends on compliance, even when rulings are unpopular, even when they appear misguided. Obedience is not endorsement. It is the price of coherence. Kennedy listened without interruption, his face neutral, eyes steady. Then he turned, slightly, toward Professor Shaw. The shift was subtle, but the room felt it. "How about you, Professor?" Shaw leaned forward just enough to reach the microphone, her voice calm, deliberate. "Under most circumstances," she said, "we follow court orders, government and private parties alike." Then she hesitated, just long enough to signal care rather than uncertainty. She added a qualification, narrow by design. She would not rule out, ever, the possibility that a sufficiently egregious order might require serious consideration of how to respond. No one gasped. No one interrupted. But the temperature changed. This was not a call to defiance. Shaw did not frame it as encouragement, or even as advice. She framed it as recognition of a tension that legal scholars have debated for generations. What happens when legal authority collides with fundamental constitutional limits? She emphasized rarity, an extremely narrow band of cases. Qualified, she called it. Qualified, yes. Kennedy did not challenge her immediately. He let the words settle. In courtrooms, silence is not empty. It is an instrument. He asked a follow-up, not accusatory, but surgical. "In some cases, then, you would advise it." Shaw answered carefully. "In an extremely narrow set of circumstances," she said, "yes, it could be considered." The exchange, brief as it was, did something irreversible. It moved the conversation from rule to discretion, from certainty to judgment. The rule of law, Kennedy knew, does not collapse through rebellion. It erodes through exceptions that feel reasonable in isolation. Once you admit that obedience is conditional, the next question is, Who decides when the condition is met? He shifted gears without announcing the turn. Do any of you believe that nationwide or universal injunctions not being abused? The question landed softly, but it carried weight. Nationwide injunctions are not a slogan. They are a procedural mechanism, one that allows a single federal judge to block a law or executive action across the entire country. Once rare, once controversial, increasingly common. One witness asked for clarification. Over what time horizon, Senator? The last few months. The broader trend. The question itself was reasonable. It was also revealing. Time matters when patterns are uncomfortable. Another witness spoke of good faith disagreements, of judges grappling with complex questions. Shaw echoed the point, saying she had not seen abuse in the last 4 months. Kennedy nodded, as if acknowledging the answer on its own terms. Then he leaned forward slightly. He said he had read her work. Articles, commentary. He did not want to get bogged down in it, he said, but he had little respect for her opinion on this issue. Not because she lacked intelligence, but because of what the record showed. When a president you agreed with was in the White House, he said, and a nationwide injunction was issued against him, you criticized the practice. You described judges as politicians in robes, as crass political actors. But now that President Donald Trump is in office, whom you dislike, nationwide injunctions suddenly taste like pumpkin pie. The metaphor was sharp, almost playful, but the accusation beneath it was not. Kennedy did not shout. He did not sneer. He spoke with the mild cadence of someone laying out arithmetic. I have to discount what you say, he continued, because I think you act on your political beliefs. And I worry that's what you're teaching your students. Shaw bristled, just slightly. She rejected the premise. She insisted her views were grounded in principle, not politics. She spoke of context, of evolving legal landscapes. Kennedy listened, expression unchanged. Then he said he would leave her out of the next question. He turned to the other witnesses. Do you think nationwide injunctions are being abused? Yes, one answered. By both sides. Republicans and Democrats are forum shopping, Kennedy asked. Certainly, the witness replied. Professor, do you disagree with that? Kennedy asked Shaw. She did not. Both sides are abusing them, she said. There are no clean hands here. The admission mattered. It reframed the debate from partisan grievance to structural diagnosis. Forum shopping is not an accusation. It is a description of incentives. When one judge can halt national policy, litigants will seek the judge most likely to agree with them. Speed replaces persuasion. Geography replaces merit. Kennedy pressed forward. Your suggestion, he said, is that when a federal judge issues a nationwide injunction, there should be an automatic stay and an expedited right of appeal. Yes, sir. Do you disagree with that? He asked another witness. I haven't given it enough thought to have a position, came the reply. Kennedy paused, then added with a hint of dry skepticism that he suspected the answer would depend on who was president. The witness denied it. No, sir. Kennedy did not argue the point. He moved to a hypothetical, carefully chosen. Suppose a president issued an executive order that clearly violated settled Supreme Court precedent. Something as basic as denying the right to counsel guaranteed under Gideon v. Wainwright. In that case, would a federal judge have the authority to issue a nationwide injunction, or should restraint still apply? The room leaned in. Hypotheticals are where principles are tested without the shelter of ideology. One witness argued for a distinction between clear and unclear law. In obvious cases, perhaps universal relief is justified. Shaw disagreed. She argued that nationwide injunctions transgress the limitations of Article 3 even when the merits seem clear. Kennedy nodded. He said he agreed. He did not believe there was any basis under Article 3, Supreme Court precedent, or English common law for nationwide injunctions. Politicians, he said, had helped judges become politicians themselves, making it up as they went along. And many of them, he added, behaved like Shaw, opposed to injunctions when they disliked the president, supportive when they did not. He turned back to her. "While I have you, Professor." He cited a date, April 22, 2024. He said she had referred to members of the Supreme Court as evil. Which justices, he asked, was she talking about? Shaw said she did not recall using that word. Kennedy produced the quote. She had been discussing a majority opinion and said Justice Elena Kagan would not be able to control the future distortion of the opinion by her evil colleagues. "Who were you talking about?" he asked. Shaw suggested a transcription error. She said it did not sound like something she would say. Kennedy pressed. "Why not own it?" he asked. "You called members of the Supreme Court evil. Which ones?" The room went quiet, not because anyone had been proven wrong, but because the contradiction was stark. On one hand, a call for respect for judicial authority and obedience to court orders. On the other, rhetoric that framed judges as moral villains. Kennedy did not need to draw the conclusion out loud. He simply said he was embarrassed she was teaching students, that she was part of the problem. He ended not with an accusation, but with an expression of disbelief. What was happening in that exchange was not personal. It was institutional, a system under strain revealing its fault lines. The rule of law depends on consistency, on restraint, on trust. And trust, once fractured, does not fail dramatically. It thins quietly, through qualifications, through exceptions, through narratives that shift with power. The hearing moved on, but the question it left behind did not. If obedience becomes conditional, if judicial tools become political levers, and if respect for courts depends on outcomes, then the system is no longer governed by law alone. It is governed by belief, and belief, when mistaken for control, carries consequences no injunction can contain. The hearing did not reset itself after that exchange. It carried the weight forward, the way a courtroom does when a witness has said something that cannot be unsaid. Senator John Kennedy knew it. So did Professor Kate Shaw, even as she straightened the papers in front of her, buying herself a moment of order in a room that had quietly lost it. Kennedy did not press immediately. He shifted deliberately from confrontation to construction. If the rule of law depends on obedience, he said, then the tools the courts use to enforce or suspend policy matter as much as the rulings themselves. Nationwide injunctions, he reminded the panel, were not written into the Constitution. They were not expressly authorized by statute. They emerged, incrementally, from equity practice, expanding in scope as the federal government itself expanded in reach. Shaw listened, chin lifted slightly, eyes forward. She had made this argument before, in print and in lectures. The problem, she believed, was not the existence of the tool, but the context in which it was deployed. When executive action moves fast and affects millions, courts must have mechanisms that prevent irreparable harm, while legality is sorted out. That was the theory. It was clean. It was defensible. It was also increasingly detached from how the tool functioned in practice. Kennedy asked her to acknowledge a simple fact. Nationwide injunctions had become common, not occasional, not exceptional. Common. Issued by judges in single districts, sometimes before a full record was developed, sometimes before the government had even filed a response. Shaw did not dispute the frequency. She qualified it. The rise, she said, reflected the pace and breadth of modern executive action. The senator nodded, as if conceding the point. Then he asked the next question. If the tool is now routine, does it still deserve extraordinary deference? The question hung there, unanswered, because it was not doctrinal. It was institutional. Tools designed for emergencies lose their legitimacy when they become standard operating procedure. Emergency powers, once normalized, are no longer emergency powers. They are governance by exception. Another witness, a former appellate clerk, stepped in. He described how nationwide injunctions had changed litigation strategy. Plaintiffs no longer needed to win on the merits everywhere. They needed to win once, in the right court, at the right moment. He spoke carefully, avoiding loaded language, but the implication was unmistakable. The courthouse had become a choke point. Kennedy seized on that. He asked about forum shopping directly, not as a moral failing, but as an incentive problem. If you know certain districts are more receptive to certain arguments, he said, and if one ruling can halt policy nationwide, why wouldn't you file there? Why wouldn't you race the government to the docket? No one contradicted him. Shaw acknowledged it was happening. Both sides, she said, Republicans and Democrats, plaintiffs and states. There were no clean hands. The admission was not dramatic, but it was devastating in its simplicity. It confirmed what the public already suspected. Outcomes increasingly depend on where you file, not just what the law says. Kennedy leaned back. He did not look satisfied. He looked concerned. When policy rises or falls based on which judge draws the case, he said, courts begin to resemble political actors, even when they are not trying to be. Perception becomes reality. Trust erodes. And once trust erodes, compliance becomes fragile. He turned to the proposal that had been circulating quietly in legal circles for months. Automatic stays, expedited appeals, not as punishment for judges, but as guardrails. A way to ensure that a single ruling does not immediately reshape national policy before higher courts can weigh in. He asked whether anyone believed this would undermine judicial independence. One witness said no. Another said it might, depending on implementation. Shaw hesitated. She acknowledged the appeal of the idea, but warned that automatic stays could leave unconstitutional policies in place longer than necessary, inflicting real harm while appeals crawl forward. Kennedy accepted the concern, then reframed it. Every system balances harm, he said. The question is, which harm we are willing to tolerate? Temporary continuation of a disputed policy or permanent damage to the credibility of the judiciary? He did not answer the question himself. He did not need to. He let the witnesses wrestle with it. The discussion circled back to constitutional limits. Article 3, the role of courts in resolving cases and controversies, not governing outcomes for non-parties. One witness argued that nationwide injunctions exceed that mandate regardless of intent. Shaw disagreed, pointing to the practical realities of modern governance. When a policy applies to everyone, she argued, limiting relief to named plaintiffs creates chaos. Kennedy did not dispute the chaos. He asked whether chaos justified expansion of judicial power. The Constitution, he reminded them, was written with inefficiency in mind. Friction was not a flaw. It was a feature. Concentrated power, even in the hands of judges, was something the system was designed to resist. The hypothetical returned, more sharply now. A blatantly unconstitutional executive order. No right to counsel. No ambiguity. No gray area. Could a judge issue a nationwide injunction then? Shaw maintained her position. Even then, she said, the authority was questionable. Her answer surprised some in the room. It was consistent with her Article 3 argument. It was also politically inconvenient. Kennedy nodded. He said he agreed. There was no textual basis, no historical practice that justified such sweeping relief. Judges, he said, were not legislators. They were arbiters. When they begin to act as emergency managers of national policy, something fundamental shifts. The tone changed again when Kennedy returned to credibility. He did not accuse Shaw of lying. He accused her of inconsistency. He reminded her, and the room, that arguments do not exist in a vacuum. They accumulate. They form patterns. When scholars criticize judicial tools under one administration and defend them under another, even if they believe their reasoning is principled, the public hears something else. Shaw pushed back. She spoke of nuance, of evolving circumstances, of the danger of freezing legal thought in time. Kennedy listened, then responded with a quieter concern. Students, he said, are watching. Future lawyers are watching. When they see legal reasoning shift with political winds, what lesson do they learn about the law's independence? That question lingered as the hearing moved toward its most uncomfortable moment. The past statement. The quote. Kennedy cited it again, not to embarrass, but to illustrate a broader problem. Language shapes legitimacy. Calling judges evil, even in rhetorical frustration, undermines the very authority witnesses were urging others to respect. Shaw denied intent. She questioned accuracy. She asked for context. Kennedy provided it. Dates, platforms, transcripts. He did not argue about her motives. He argued about consequences. Officers of the court, he said, carry special responsibility. Their words do not stay in classrooms. They travel. They harden attitudes. They justify defiance by others less restrained. The room went still, not hostile, reflective. This was no longer about Shaw alone. It was about a culture that had normalized scorched-earth rhetoric in legal debate, even as it demanded obedience from everyone else. The contradiction was stark, and it did not require a verdict to be understood. As the witnesses offered closing thoughts, the answers grew less confident, more conditional. The certainty that had opened the hearing was gone. In its place was an uneasy acknowledgement that the system was straining under pressures it was not designed to absorb. Executive action was broader. Litigation was faster. Judicial tools were sharper. And the public's patience was thinner. Kennedy ended this phase of questioning without flourish. He did not summarize. He did not declare victory. He let the record speak for itself. A record of qualifications layered on principles, of exceptions layered on rules, of tools expanded beyond their original intent. What the hearing revealed was not corruption or conspiracy. It was something more subtle and more dangerous. A gradual acceptance that power could be bent without consequence, that narratives could be controlled if framed correctly, that legitimacy could be assumed rather than earned. As the panel broke for the next segment, the unresolved question remained suspended over the room. If courts are asked to do more than they were designed to do, and scholars are willing to justify that expansion depending on circumstance, who bears responsibility when the public decides the system no longer deserves its obedience? That question would not be answered in the hearing room, but it would shape everything that followed. By the time the hearing moved into its third phase, the posture of the room had changed. Not visibly, not in any way that would register on a wide camera shot, but in the small human tells that matter more than transcripts. Shoulders that had been squared were now slightly rounded. Answers that had once arrived cleanly now came with prefatory clauses. Senator John Kennedy noticed all of it. He had been counting on this moment. He did not begin with a question. He began with a document. It was not dramatic. No binder slammed onto the desk, no theatrics, just a printed packet, thin enough to look harmless, slid forward by a staffer and placed squarely in front of him. Kennedy tapped it once with his finger, not to emphasize its importance, but to mark a transition. Theory, he seemed to be saying, had had its turn. Now came consequences. He referred to a timeline, not an allegation, a sequence. Over the last several years, nationwide injunctions had been issued at an accelerating pace, often within days of executive actions being announced, sometimes within hours of lawsuits being filed. In several cases, he noted, the government had not yet fully briefed the court. In others, the injunctions applied far beyond the plaintiffs who had standing to sue. He asked the witnesses to walk him through what happens next. A former government attorney on the panel explained the mechanics. Once an injunction is issued, agencies halt enforcement. Guidance is frozen. Contracts are paused. States wait. Regulated entities scramble. Even if the injunction is later narrowed or overturned, the disruption does not simply rewind. Momentum is lost. Policy windows close. Markets react. The injunction, temporary in theory, becomes permanent in effect. Kennedy let the explanation continue uninterrupted. Then he asked the question that had been building beneath every answer so far. If a single district judge can impose nationwide consequences immediately, where does accountability reside in the interim? No one answered directly, because there was no clean answer. The appellate process, they said. Expedited review, when possible. Emergency motions. Stays. But Kennedy pressed. Those mechanisms are discretionary. They take time. And in the meantime, the injunction governs. The judge who issued it does not answer to voters. The appellate court may not hear the case for weeks or months. Congress is sidelined. The executive is restrained, and the public is left watching a policy battle play out through procedural maneuvers they barely understand. This, Kennedy suggested, is not how legitimacy is built. He returned to the proposal of automatic stays and fast-track appeals, but now he framed it differently. Not as reform, but as containment. A way to keep the judiciary within its intended role while preserving its checking function. He asked whether any witness believed that asking judges to wait for appellate confirmation before imposing nationwide effects truly threatened judicial independence. The answers were more cautious now. One witness conceded that independence does not require immediacy. Another acknowledged that structural limits can coexist with robust review. Professor Kate Shaw remained measured. She reiterated her concern that automatic stays could allow unconstitutional policies to persist, harming individuals while courts deliberate. Kennedy did not dispute the harm. He asked whether harm was ever entirely avoidable in constitutional design. The Constitution, he reminded the room, tolerates delay. It tolerates friction. It tolerates inefficiency, precisely because those features slow the concentration of power. Speed, he implied, is not always a virtue in governance. He shifted to Article 3 again, but this time he did not cite doctrine. He cited history, the English common law tradition, the early American judiciary. Courts resolved disputes between parties. Relief was tailored. Broad injunctions affecting non-parties were the exception, not the rule. The expansion of nationwide injunctions, he argued, did not arise from a clear mandate. It arose from convenience. Convenience, however, is not a constitutional principle. The witnesses responded with practicality. Modern government, they said, does not resemble the 18th century. Policies are national by default. Limiting relief to named plaintiffs creates a patchwork of enforcement that is confusing and unfair. Shaw argued that universal injunctions sometimes prevent chaos by ensuring uniformity. Kennedy listened, then asked a quiet but devastating question. Uniformity under whose authority? The question reframed the entire argument. Uniformity imposed by Congress carries democratic legitimacy. Uniformity imposed by the executive carries electoral accountability. Uniformity imposed by a single judge carries neither. Even if well-intentioned, even if correct on the merits, it concentrates power in a way the system was designed to resist. The witnesses shifted again, their answers more defensive now, their cadence less confident. They spoke of necessity, of gaps in legislative action, of courts stepping in where other branches fail. Kennedy did not deny that courts sometimes play that role. He asked whether stepping in had quietly become stepping over. He returned to rhetoric, but not as a sideshow. Language, he said, signals intent. When judges are described as heroes saving democracy one day and villains undermining it the next, the public absorbs the message that law is merely another battlefield. Shaw pushed back, emphasizing the importance of criticizing decisions without attacking institutions. Kennedy agreed in principle. Then he reminded her of the earlier quote, the word evil. He did not linger on it. He did not repeat it. He simply noted that such language does not stay confined to academic debate. It migrates. It becomes justification. He asked whether she believed lawyers advising clients to obey court orders could plausibly maintain that advice while publicly characterizing judges as morally corrupt. Shaw answered carefully. She distinguished criticism from defiance. Kennedy accepted the distinction, then pointed out the slippage. When trust erodes, he said, people stop listening to distinctions. The room felt smaller now, not physically, but psychologically. The confidence that had marked the opening statements was gone. In its place was an uneasy recognition that the system's guardrails were thinner than anyone wanted to admit. Kennedy summarized nothing. He never did when the point had landed. He moved instead to consequences beyond the courtroom. Public perception, polling data showing declining trust in the judiciary, rising rhetoric about illegitimacy, calls, once fringe, now mainstream, to ignore or defy rulings viewed as partisan. He did not accuse the witnesses of causing this shift. He implied something more troubling. That well-intentioned legal arguments, when untethered from consistency and restraint, contribute to a climate where defiance feels reasonable. The witnesses nodded, some reluctantly, some openly. No one denied the trend. As the third phase of questioning drew to a close, the hearing had accomplished something rare. It had stripped away the comfort of abstraction. Nationwide injunctions were no longer just tools. They were accelerants. Rhetoric was no longer just speech. It was infrastructure, and discretion, once celebrated as nuance, now looked uncomfortably like power without a counterweight. Kennedy leaned back for the first time in nearly an hour. He looked tired, but not satisfied. The hardest part of the argument was still ahead. Because diagnosing a problem is easier than confronting what follows, when a system realizes it has been relying on restraint that can no longer be assumed. The illusion that institutions will self-correct, that actors will police themselves out of respect for norms, had been the quiet glue holding everything together. That illusion, Kennedy suggested without saying it outright, was wearing thin. What happens next, he implied, would depend not on law books, but on whether those entrusted with legal authority were willing to accept limits before the public imposed its own. The room fell into another pause. Not the tense pause of confrontation, but the heavier pause of recognition. The kind that arrives when everyone understands that the final act will not be procedural. It will be moral. The final phase of the hearing unfolded without announcement. There was no gavel strike to mark the transition, no formal declaration that the conversation had reached its end. It simply slowed. The way proceedings do when everyone in the room understands that the remaining questions are no longer technical, and that whatever answers are given will linger long after the transcript is filed away. Senator John Kennedy did not return to doctrine. He did not cite Article 3 again or revisit the mechanics of injunctions. He shifted instead to something far less comfortable for everyone present: consequence without immediacy. The kind of consequence that does not show up in court opinions, but in public behavior. He spoke about obedience, not as a legal requirement, but as a social habit. Court orders, he said, have no army, no enforcement arm of their own. They rely on acceptance, on a shared belief that even when a decision feels wrong, even when it stings politically or personally, it is still binding because the alternative is worse. That belief, he suggested, is fragile. When legal scholars speak as if judicial authority is contingent on outcomes, when judges are praised or condemned based on who benefits, the public learns a lesson whether anyone intends to teach it or not. That lesson is not subtle. It is that law is negotiable, that compliance is optional, that power is legitimate only when it aligns with one's own sense of justice. Kennedy let that thought sit. He did not accuse Professor Kate Shaw or any other witness of encouraging defiance. He said something more unsettling. He said systems collapse not because leaders openly call for rebellion, but because enough people quietly decide the rules no longer apply to them. Shaw responded with care. She reiterated that her arguments were about institutional design, not personal allegiance. That criticism of the courts is not the same as rejection of their authority. That robust debate strengthens, rather than weakens, democratic institutions. Kennedy did not disagree. He accepted the premise fully. Debate is necessary. Criticism is healthy. But, he said, there is a line between critique and delegitimization, and that line is not always crossed with a shout. Sometimes it is crossed with repetition, with tone, with selective outrage. He returned, one last time, to the word that had haunted the hearing: evil. He did not demand an apology. He did not press for retraction. He asked a different question altogether. When people hear judges described that way, he asked, "Do you believe they will distinguish between your academic meaning and a moral indictment?" Shaw hesitated. The hesitation was not evasive. It was human. She acknowledged that words can travel farther than intended, that rhetoric can harden, that scholars bear responsibility for how their language is received, not just how it is meant. The room exhaled, almost collectively, not in relief, but in recognition. This was no longer about any single statement or any single witness. It was about the cumulative effect of years of escalating language, accelerated litigation, and expanding judicial tools, each element defensible on its own. Together, destabilizing. Kennedy spoke then about reform, but not in legislative terms. He spoke about restraint as a professional ethic. Judges restraining themselves from imposing national solutions where narrower relief would suffice. Scholars restraining themselves from absolutist rhetoric that frames disagreement as moral depravity. Lawyers restraining themselves from treating forum selection as a substitute for persuasion. Restraint, he said, is invisible when it works. It does not trend. It does not generate headlines. It does not satisfy audiences hungry for certainty. But it is the difference between a system that bends and one that breaks. The witnesses listened. Some nodded. Some stared down at their notes. The confidence that had marked the opening of the hearing was gone, replaced by something quieter and heavier. An awareness that the system they studied and taught was operating closer to its limits than most were willing to admit. Kennedy concluded without summation. He did not restate the arguments. He did not declare a winner. He asked a final question, framed not as a challenge but as an invitation. If courts continue to absorb political conflicts that other branches cannot resolve, and if legal actors continue to justify extraordinary measures as routine, what happens when the public stops believing those measures are neutral? No one answered. There was nothing left to add. The microphones were switched off. Staffers gathered documents. The witnesses rose, thanked the committee, and filed out in the orderly way Washington has perfected. On paper, nothing had changed. No law was passed. No rule was amended. No injunction was issued or stayed. And yet, something fundamental had been exposed. The hearing had not revealed corruption or conspiracy. It had revealed dependency, a system increasingly reliant on good faith, consistency, and restraint, at a moment when all three were under strain. Nationwide injunctions had become pressure valves for political conflict. Rhetoric had become sharper as trust thinned, and the assumption that institutions would self-correct had begun to look more like wishful thinking than design. Outside the hearing room, the machinery of government continued uninterrupted. Agencies drafted guidance, lawyers filed motions, judges issued orders. Life went on, as it always does. But beneath that continuity was a question that could not be legislated away. If obedience to law depends on belief in its fairness, and belief depends on consistency, what happens when consistency becomes conditional? That question did not belong to John Kennedy or Kate Shaw or any single institution. It belonged to the system itself, and to the public that would ultimately decide whether the rules were still worth following. The illusion that control can be maintained through narrative alone, through clever arguments and procedural leverage, had been quietly dismantled over the course of 4 hours. What remained was something far less comfortable. An understanding that power, once stretched beyond its design, does not fail dramatically. It fails quietly, through exceptions that feel reasonable, through tools that become habits, through words that outpace responsibility. And by the time the consequences arrive, no injunction, nationwide or otherwise, can put the system back exactly where it was.